Chapter 15, Subtopic 5: The Impact of Social and Environmental Matters on the Statutory Audit. Section Overview. ISA 250. Consideration of laws and regulations in an audit of financial statements. Other relevant ISAs: IAPS 1010. The consideration of environmental matters in the audit of financial statements, now withdrawn. Substantive procedures to detect a material misstatement due to environmental matters. Section 5.1. International Standard on Auditing 250. Consideration of laws and regulations in an audit of financial statements. As discussed in a previous chapter, International Standard on Auditing 250 requires the auditor to obtain sufficient appropriate evidence in respect of non-compliance with laws and regulations, which might be expected to have a direct effect on material amounts and disclosures in the financial statement. Non-compliance could be over a variety of social or environmental matters such as health and safety legislation, equal opportunities legislation, or anti-pollution legislation. Social or environmental matters can have a direct impact on the statutory audit. This is because a breach of social or environmental legislation may have a material impact on the financial statement. For example, if an entity is in breach of social or environmental legislation or other regulations, it may need to include a provision for fines or penalty in its financial statement. It may need to disclose a contingent liability for a possible settlement in a court case, where the entity is facing a civil lawsuit for damages arising from a breach of environmental or social regulations. It may be required by law to improve working conditions or rate of pay, which will affect labor costs. It may be necessary to write down the value of certain assets due to impairment. Section 5.2. Other relevant ISAs. There are some other international standards on auditing that include a reference to social or environmental aspects of the external audit. International Standard on Auditing 315, identifying and assessing the risk of material misstatements through understanding the entity and its environment. The auditor should evaluate the environmental risk facing a client entity and the controls that are in place to manage those risks. International Standard on Auditing 315 therefore requires the auditor to be aware of 1. Relevant environmental legislation. 2. The nature of the production processes used by the entity. And 3. The general impact of the entity's activities on its physical environment. Environmental risks will include 1. Contingent liabilities arising from legal claims against the entity as a result of environmental damage or a breach of environmental protection regulations. 2. Provisions that may be required for restoration costs. 3. Expenditure that may be required to modify or clean the production processes and redesign products in order to meet environmental regulations. International Standard on Auditing 330. The auditor's responses to assessed risk. International Standard on Auditing 330 requires the auditor to design audit procedures that take into consideration the environmental risk assessment. Designing suitable audit procedures to assess environmental risk will probably require a high level of professional judgment from the auditor. In particular, judgment may be required as to whether a liability exists and if so, how it should be monitored. As a result, the auditors may need to take advice from external experts, and Written management representations should be obtained about the environmental risk. International Standard on Auditing 540, Audit of Accounting Estimates. International Standard on Auditing 540 includes a requirement that the auditor should review the approach taken by management to making estimates that relate to environmental risk. Section 5.3 IAPS 1010, the consideration of environmental matters in the audit of financial statements, now withdrawn. Whilst IAPS 1010 has been formally withdrawn, the substance of its content remains a useful reference. Environmental matters were defined by IAPS 1010 as initiatives to prevent, reduce, or repair damage to the environment or to conserve resources. Consequences of violating environmental laws or regulations and consequences of environmental damage. For many companies, environmental matters are not significant. However, where environmental matters are significant, there may be a risk of material misstatement in a financial statement. For example, environmental risk may be significant for an oil exploration company, a chemical production company, or a provider of energy from nuclear power. The following examples were given of environmental matters that might affect the financial statement. 1. The introduction of new environmental laws and regulations may lead to an impairment of assets. For example, new laws may be introduced relating to assets containing dangerous substances such as asbestos. When this happens, entities may be required to recognize the impairment of non-current assets that contain the substance. 2. An entity may be guilty of non-compliance with legal requirements concerning environmental matters, such as emission or waste disposal. In some cases, there may be new environmental legislation with retrospective effect. In all these circumstances, the entity may be required to make accruals for remediation work and for paying compensation or legal costs. Some entities incur environmental obligations as a direct byproduct of their core businesses. This applies, for example, to companies in the extraction industries, oil and gas exploration or mining, chemical manufacturers, and waste management companies. 4. A provision may be required as a result of constructive obligations that the entity incurs from a voluntary initiative. For example, an entity may have identified contamination of land. Although under no legal obligation, it may have decided to remedy the contamination, or it may be expected to remedy the contamination because of its past actions, because of its concern for its long-term reputation and its relationship with the community. 5. An entity may need to disclose in the financial statements the existence of a contingent liability where the expense relating to environmental matters cannot be reasonably estimated. 6. In extreme situations, non-compliance with certain environmental laws and regulations may affect the ability of an entity to continue as a going concern. This may affect the disclosures and the basis of preparation of the financial statements. Risk assessment and internal control. IAPS 1010 stated that in order to obtain a general understanding of relevant environmental laws and regulations, the auditor should carry out the following procedures. 1. The auditor should use his existing knowledge of the entity's industry and business. 2. The auditor should ask the management of the entity questions about the environmental laws and regulations that may be expected to have a fundamental effect on the operation of the entity. 3. The auditor should also ask the management of the entity questions about the entity's policies and procedures regarding compliance with relevant environmental laws and regulations. Managers with responsibility for environmental matters should be questioned, as well as senior management. 4. The auditor should discuss with management the policies or procedures that the entity has adopted for identifying, evaluating, and accounting for litigation claims and assessments. The auditor may find evidence of a risk of a material misstatement in the financial statements due to environmental matters. For example, evidence of such a risk may be discovered in the following circumstances. 1. The auditor might discover the existence of a report about material environmental problems prepared by environmental experts, internal auditors, or environmental auditors. 2. The auditor might discover evidence of a violation of environmental laws and regulations, which is mentioned in correspondence with regulatory agencies or a report issued by a regulatory agency. 3. The auditor may find that the name of the entity is included in a public register or plan for the restoration of soil contamination. 4. There may be reports or comments in the press or other media about the entity and its involvement or responsibility for major environmental problems. 5. The auditors may find comments relating to environmental matters made in solicitors' letters to the entity. 6. The auditors might suspect environmental risk when they find large or unusual fees charged by environmental consultants or large payments of penalties as a result of a violation of environmental laws and regulations. Section 5.4. Substantive procedures to detect a material misstatement due to environmental matters. The external auditors may design substantive tests for detecting a material misstatement in a financial statement due to environmental matters. The substantive test may consist of the following checks. 1. A review of documents such as minutes of meetings, board meetings, audit committee meetings, environmental committee meetings. Industry information, media comments, environmental reports and audits, internal audit reports, due diligence reports, reports from regulators, correspondence with environmental agencies, correspondence with solicitors. 2. The auditor may use an external expert to provide advice in accordance with International Standard on Auditing 620. 3. The auditor may use the work done by the internal audit department to investigate environmental risk and controls within the entity. 4. The auditor may make some inquiries about the insurance cover obtained by the entity for its environmental risk. 5. The auditor should obtain written representations from management that they have considered the effect of environmental matters on the financial statement and that they are not aware of any material liabilities or contingencies arising from environmental matters, including those resulting from illegal or possibly illegal acts. They are not aware of environmental matters that may result in a material impairment of assets, or they are aware of such matters, they have disclosed all the relevant facts to the auditor. Next point. The auditor should ask about the policies and procedures of management for assessing the need to write down the carrying amount of assets in a situation where any impairment of assets has occurred due to environmental matters. The auditor should also consider the adequacy of any write-down of assets that the entity has made. Next point. The auditor should ask about the policies and procedures that are used by the entity to help identify liabilities, provisions, or contingencies arising from environmental matters. Next point. The auditor should ask about events or conditions that may give rise to liabilities, provisions, or contingencies arising from environmental matters. For example, the auditor should ask whether there have been violation of environmental laws and regulations, penalties arising from violation of environmental laws and regulations, or claims and possible claims for environmental damage. Next point. If the entity has identified a need for site cleanup costs, restoration costs, or penalty arising from non-compliance with environmental laws and regulations, the auditor should inquire about any related legal claims or possible legal claims. Next point. The auditor should ask whether there is any correspondence from regulatory authorities relating to environmental matters. When such correspondence exists, the auditor should consider whether the correspondence indicates the existence of a liability, provision, or contingent liability. Next point. When property, land or buildings has been abandoned, purchased, or closed during the period, the auditor should ask about regulatory requirements for cleaning up the site or about the intention of the entity with regards to cleanup, future removal of the building, and the site restoration at the end of the asset's life. Next point. The auditor should perform analytical procedures and consider as far as practicable the relationships between financial information and quantitative environmental information. For example, the auditor might analyze the entity's environmental records and establish whether there is relationship between raw materials consumed and waste production or emissions. Next point. The auditor should review and test the process used by management to develop accounting estimates and disclosures relating to environmental matters. A review might consist of obtaining an estimate from an independent expert to corroborate the estimate of management. Alternatively, the auditor might be able to verify the estimate of management from subsequent events after the reporting period. Next point. For all liabilities, provisions, or contingencies related to environmental matters, the auditor should consider whether the assumptions underlying the estimate are appropriate and whether the amount of the liability, provision, or contingency is reasonable. Next point. The auditor should review the adequacy of the disclosures in the financial statement about the effect of environmental matters. Subtopic 6. Social and environmental reports and audits. Section Overview. The significance of social and environmental reporting. Environmental reports, environmental audits, social reports and audits, audit evidence for social and environmental reports. Section 6.1. The significance of social and environmental reporting. Under pressure from public opinion, many entities are now aware of social and environmental issues and the effect that the entity has on social and environmental matters in the country where it operates. If it fails to recognize social and environmental problems and is not seen to be doing something about them, an entity's reputation may be at risk. Reputational risk can have consequences for customer demand for the entity's product. Many members of the public may refuse to buy goods from companies or invest in the shares of companies unless those companies have healthy social and environmental policies. The senior management of some major entities would argue that they show more concern for social and environmental matters than governments. It has therefore become increasingly important for companies to demonstrate their social and environmental policies by publishing social and environmental reports or through their website, advertising, and media reports. In most countries, including Nigeria, reporting on social and environmental issues is voluntary. However, the European Union has recently issued an account modernization directive requiring quoted companies to publish a business review each year. This review should include information about a range of issues, including social and environmental matters, environmental policies. An entity's environmental policies might cover such matters as energy consumption, pollution, the use of natural resources and sustainability of the business, use of recycled materials. Social policies. Social policies might cover such areas as employees' rights, for example, right to trade union membership, employee training and development, human rights, child labor in developing countries, equal opportunities, health and safety matters, relationship with the local community, supporting local, national, and international good causes. Many large companies now publish a social and environmental report, sometimes called a sustainability report. The aim of such reports is to demonstrate that the company has a strong social and environmental conscience and is actively engaged in improving social and environmental conditions. Credibility can be added to this report by an independent verification statement from a firm of accountants or similar firm of independent external experts. Section 6.2 Environmental Reports. Many larger entities whose activities have an environmental impact now publish an annual environmental report or sustainability report. This may be published as part of the company's annual report. More often, it is published as a separate document. The content of environmental reports are not regulated, and although the external auditors may review the report, the content of environmental reports are not regulated, and although the external auditors may review the reports, they are not included within the scope of the statutory audit opinion. However, some entities engage external environmental experts to review and report on their environmental reports. An environmental report is seen as an important indicator of the commitment that the entity is giving to its impact on the physical environment and the future of the planet and its people. An environmental report may cover such matters as environmental performance targets and the extent to which they have been achieved. For example, in its 2005 sustainability report, Shell reported on whether it had met targets with respect to oil spills and greenhouse gas emissions. 2. Relevant environmental regulations imposed on the entity and the extent to which they are complied with. 3. Compliance with industry standards or other environmental standards. 4. The entity's policy on sustainable development. Sustainability refers to the ability of the entity to meet the needs of the present generation of customers without adversely affecting future generations. For example, a supplier of timber may have a policy of reforestation of large geographical area to replace timber that they cut down. Section 6.3 Environmental Audit. An environmental audit can be defined as a management tool comprising a systematic, objective assessment of how well an entity is performing with the aim of safeguarding the environment by enhancing management control of environmental practices, including compliance with appropriate legislation and regulations. An environmental audit may be performed by the entity's external auditors or the internal auditors or external environmental experts. Environmental audits are not subject to the same high level of regulation as financial audits. However, if an environmental audit is performed by professionally qualified accountants, it would be subject to the usual requirements of codes of professional practice for accountants. Typically, an environmental audit involves an assessment of all impacts of the entity's activities on the environment, including 1. Compliance with environmental regulations, for example, on pollution of land, water, and air. 2. Waste disposal. 3. Recycling policies. 4. Sourcing of raw materials. The accountant performing an environmental audit will determine the environmental policies that the organization has in place and assess the entity's performance based on measurable performance criteria. For example, actual performance measures for pollution might be compared with pre-established targets. Section 6.4 Social Reports and Audits. Many entities now publish a social report or social information, often together with an environmental report. This report may be subject to an audit or review process by the entity's external auditors, internal auditors, or external experts. An extract from the Social Report section of Shell's 2005 Sustainability Report gives some indication of the topics that this report might cover. Example: extract from Shell's 2005 Sustainability Report. Living consistently by the Shell General Business Principle remains an important part of our culture. It requires concerted efforts, particularly as the search for more oil and natural gas continues to take us to difficult locations and sensitive countries. Human rights. We turn our commitment to human rights into action in many ways. One is by providing employees with a safe and healthy workplace and access to unions, grievance procedures, and staff councils. Another is avoiding the use of child labor. A third is taking security measures that do not compromise the rights of the communities in which we operate. We use independent country risk assessment from a leading international human rights institution to help us understand how human rights risk when we enter a new location. Risk areas are highlighted, such as labor rights of migrants workers or behavior of security forces. We then develop a set of actions to help us avoid violating rights in these risk areas. Contractors. Contractors must manage HSE in line with our health, safety, and environment standard and are expected to follow our or equivalent business principles. In many countries, we work with contractors to help them understand and comply with these requirements. If they cannot, we are required to review the relationship. In 2005, we cancelled 63 contracts because of such concerns. Our people. We are committed to preventing incidents such as spills, fires, and accidents that are a risk to people, the environment, and our facilities. All shell companies, contractors, and joint ventures we control are obliged to operate in line with our health, safety, and environment standard. It requires them to take a systematic approach to managing their HSE risk. All our major facilities must be certified to the international ISO 14001 environmental standard. Sites must have emergency response plans and test them regularly so that damage can be minimized in the event of an incident. We investigate serious incidents and near misses so we can learn from them and help prevent similar incidents happening in the future. Labor rights and child labor. We have made a specific commitment not to exploit children through direct employment or indirectly through joint ventures, contractors, or suppliers. By the end of 2005, shell companies in nearly 90% of the countries where we operate had procedures to prevent the use of child labor. Shell companies in nearly 70% of countries where we operate screened their contractors for child labor, and nearly 2/3 screened their suppliers, up from less than a third 5 years ago. Shell in society, our contribution. Our biggest contribution to society is through our products, the energy and petrochemicals that modern economies need. But our operation can also make a strong positive contribution to development, turning payments to government into social benefits. In 2005, we paid our $19 billion in corporate taxes and $2 billion in royalties. We collected more than $72 billion in sales tax and excise duties. In energy-producing countries, oil and natural gas revenues can bring widespread benefits. Managed well, the money can fund services such as schools and hospitals and diversify the economy. Managed badly, it can stimulate corruption, breed conflict, and hurt the country's competitiveness. We encourage and support host government efforts to use energy revenue wisely. We enforce our policy of zero tolerance of bribes and facilitation payments. Section 6.5. Audit evidence for social and environmental reports. In most countries, there are currently only limited statutory requirements or no statutory requirements at all about social and environmental reporting. For example, in the European Union, quoted companies are required to include some information about environmental and social risk in their annual business review. But there are no rules about what these disclosures should contain. Since companies decide what to include in their social and environmental reports, the report may contain very few verifiable numbers and may consist largely of narrative, words, not numbers. However, some companies have chosen to include quantified performance measurements in their social and environmental reports. So, some companies publish sustainability reports. These report figures for financial performance, social performance, and environmental performance. Sustainability reports are sometimes referred to as triple bottom line reporting because they present performance reports for each of these three areas. When social and environmental reports include quantified performance figures, performance is often reported by comparing actual performance against targets for a number of different key performance indicators or KPIs. The KPIs vary according to the nature of a company and its business. To make these reports more convincing and believable to users, the figures may be audited to verify that they are reliable. In the exam, you may be asked to 1. Propose a number of different KPIs for a social and environmental report, and 2. Provide suggestions about how an auditor might obtain evidence to verify the reliability of the performance measurements in the reports for each KPI. Example: KPIs. The KPIs and sources of audit evidence in the table below are illustrative only. They provide an indication of the nature of performance measurements for social and environmental issues. The selection of KPIs is a matter of choice for the company itself, and the performance measurements used therefore vary widely. Remember that social issues include matters relating to employment and employees, as well as matters relating to society as a whole and the corporate citizenship of the company. Key performance indicator, possible source of audit evidence. Social indicators, employees. Percentage of employees who are women or from particular ethnic groups or in particular age groups as evidence of non-discrimination. The possible source of audit evidence is their personnel file. KPI, staff turnover rate. The possible source of audit evidence is personnel file. KPI, spending on employee training. Audit evidence is cash book or training accounts in the main ledger. KPI, absentee levels. Audit evidence, payroll records, records of medical evidence of sick leave. KPIs, injuries at work, number or expressed as a percentage of workforce. Audit evidence, health and safety records. Social indicators, customers and general public. KPI, customer satisfaction measurement, number of complaints as a percentage of sales orders. Audit evidence, records in sales administration. KPI, spending on charitable causes or investment in particular communities. Audit evidence, cash book or relevant expenditure accounts in the main ledger. Environmental indicators, increase or reduction in consumption of natural resources, water and energy. Audit evidence, invoices from utility companies. KPI, pollution level. Audit evidence, official regulatory measurements. KPI, percentage of waste recycled. Audit evidence, observation. KPI, investment in environmental friendly materials such as recycled paper. Audit evidence, observation, purchase orders. Subtopic 7, exposure drafts and other current debates. Section overview. ED July 2013, reporting on audited financial statements, proposed new and revised international standard on auditing. ED December 2012, responding to a suspected illegal act. ED April 2011, proposed revision to ISAE 3000. XBRL, the emerging landscape. Significant, unusual, or highly complex transactions. Reform of the audit profession. 7.1. Section 7.1. ED July 2013, reporting on audited financial statements, proposed new and revised ISAs. The auditor's opinion on the financial statement is valued. However, many have called for the auditor's reports to be more informative, in particular for auditors to provide more relevant information to users based on the audit that was performed. In response, the IAASB, that's the International Auditing and Assurance Standard Board, issued an exposure draft in July 2013, which proposes a number of revisions to the International Standard on Auditing, aims at improving the auditor's report on audited financial statements. The proposed ISAs represent a significant change in practice, but enhanced auditors' reporting. In viewing, auditor reporting is viewed as critical to the perceived value of the financial statement audit, and thus to the continued relevance of the report of the auditing profession. Expected benefits from the proposed ISA revision include: 1. The primary beneficiaries of the IAASB work on auditor reporting will be investors, analysts, and other users of the auditor's reports. An audit enhances the credibility of the financial statement and can directly or indirectly improve the quality of financial reporting. Because the auditor's report is the key deliverable addressing the output of the audit process for users of the audited financial statements, the IAASB is of the view that changes in the auditor reporting may have positive benefits to audit quality or users' perception of it. This in turn may increase the confidence that users have in the audit and the financial statement, which is in the public interest. 2. Enhanced communicative value of the auditor's report, providing more transparency about the audit that was performed. Increasing attention by management and those charged with governance to the disclosures in the financial statement to which reference is made in the auditor's report, e.g., key audit matters, going concern, which may further improve the quality of financial reporting. Renewed focus of the auditor on matters to be reported, which could indirectly result in an increase in professional skepticism among other contributors to audit quality. Next point, enhanced communications between the auditor and those charged with governance. For example, more robust dialogue about the key audit matters that will be communicated in the auditor's report. The proposed ISAs and key enhancements to auditor reporting are: ISA and the proposed revision. Proposed ISA 700 revised, forming an opinion and reporting on financial statements. Revision to establish new required reporting elements, including a requirement for the auditor to include an explicit statement of auditor independence and disclose the sources of relevant technical requirements, and to illustrate this new element in example auditor's report. Proposed ISA 701, communicating key audit matters in the independent auditor's report. New standard to establish requirements and guidance for the auditor's determination and communication of key audit matters. Key audit matters, which are selected from matters communicated with those charged with governance, are required to be communicated in auditor's report for audit of financial statements of listed entities. Auditors of financial statements of entities other than listed entities may also be required or may decide to communicate key audit matters in the auditor's report. Proposed ISA 260 revised, communication with those charged with governance. In light of proposed ISA 701, amendments to the required auditor communication with those charged with governance, for example, to include communication about the significant risk identified by the auditor. Proposed ISA 570 going concern. Amendments to establish auditor reporting requirements relating to going concern and to illustrate this reporting within the auditor's report in different circumstances. Proposed ISA 705 modifications to the opinion in the independent auditor's report. Amendments to clarify how the new required reporting elements of proposed ISA 700 are affected when the auditor expresses a modified opinion, and to update the illustrative auditor's reports accordingly. Proposed ISA 705 modifications to the opinion in the independent auditor's report. Amendment to clarify how the new required reporting elements of proposed ISA 700 are affected when the auditor expresses a modified opinion, and to update the illustrative auditor's report accordingly. Proposed ISA 706 emphasis of matter paragraphs and other matter paragraphs in the independent auditor's report. Amendments to clarify the relationship between emphasis of matter paragraphs, other matter paragraphs, and the key audit matters section of the auditor's report. Proposed conforming amendments to other ISAs. Conforming amendments related to communicating key audit matters. Section 7.2 ED December 2012 responding to a suspected illegal act. Confidentiality is one of the 5 fundamental principles in the Code. The principle imposes an obligation on all professional accountants to refrain from disclosing outside the accounting firm or employing organization confidential information acquired as a result of professional and business relationship without proper and specific authority, unless there is a legal or professional right or duty to disclose. Section 140 confidentiality identifies 3 circumstances where professional accountants are required or may be required to disclose confidential information. 1. Disclosure is permitted by law and is authorized by the client or the employer. 2. Disclosure is required by law. And 3. There is a professional duty or right to disclosure when not prohibited by law. In November 2010, the IESBA approved a projected proposal to provide additional guidance for all professional accountants on how to respond when encountering a suspected fraud or illegal act. The project was to address 2 main elements: the process to be followed when a professional accountant encounters a suspected fraud or illegal act, and the circumstances in which a professional accountant would override the fundamental principle of confidentiality and disclose the matter to an appropriate authority. The exposure draft provides background for and an explanation of the proposed changes to the Code of Ethics for Professional Accountants to address the circumstances where a professional accountant in public practice or business shall or has a right to override the fundamental principle of confidentiality and disclose a suspected illegal act to an appropriate external authority. The IESBA recognizes that ISA 250, Consideration of Laws and Regulations in the Audit of Financial Statements, states that the auditor's professional duty to maintain confidentiality of client information may preclude reporting identified or suspected non-compliance with laws and regulations to a party outside of the entity. Subject to responses to the proposals on exposure, the IAASB will consider whether consequential changes to ISA 250 may be needed in light of changes to the code.